Good evening and welcome to yet another edition of Law and Order, brought to you, of course, exclusively by Channel I. As you know, my dear viewer, the objective of this show is to educate you on matters pertaining to the law which are of significance to your everyday lives. And in view of this, we take on various subjects which have some relevance to our day-to-day lives. And tonight, we will be taking a closer look at an area of law which has got a lot of attention over the past couple of years. That is because it is a very new law. It was introduced to Sri Lanka just as recently as in 2016. What am I talking about? The Right to Information Act. And to help us to get to the bottom of what this right is and how we use this simple act for our benefit, we have with us today Ms. Sankitha Gunaratne, who is the manager of the Right to Information program of Transparency International Sri Lanka. Good evening, Sankitha.
Good evening.
It's, as always, good to have you on the show.
Thanks very much for having me.
So, just to start off with, just tell us what are the salient features of the Right to Information Act that our viewers should be aware of?
Yes, so the right to information is basically the right for any citizen of Sri Lanka to access any information that's held on record at a public authority. So in terms of the salient features, some of the viewers might know that our law has been ranked third in the world.
Is that so?
At the time of introduction, it was third in the world, and then recently after Afghanistan kind of overtook us, we're now fourth. That doesn't mean our law got any worse, really.
Yes, of course.
So why this has been ranked so high is because there have been very positive aspects to this law. One is that when you ask for information, you're not bound to give reasons as to why you want information. Now, the general thing you encounter is that you're asked, why do you want this information? How is this relevant to you? If I want to know, sitting here, how a road in Jaffna was built, I still have the right to access that. And public officials are actually debarred from asking a citizen why they want it. So it's quite a significant shift. Another thing is that when and if they refuse information to a citizen, they are bound to give very specific reasons, and those reasons must be reasons that are given in the Right to Information law. And beyond that, they have to justify as to why that reason applies. Now, there's this sense that a lot of information can be refused, that they'll cite national security always, that they will cite privacy always. But even if they do, they have to show how exactly the information disclosure would impact national security. And that's not always an easy thing to do. So I would say 90% of the information you should be able to get without any challenge. So they have to justify as to why information is refused. Another thing is in instances where there is a threat to the life or liberty of any citizen, and the information you're asking for relates to that, then the information can be requested within 48 hours.
Oh, I see.
Yes, so this is a significant improvement as well. In addition to this, there's something called a public interest override. Now, this might sound really technical, but what it really means is that even in situations where information may seem to be able to be refused under one of these justifiable grounds, so say national security or privacy, there is an actual prejudice to someone's privacy, that kind of example. Still, if the public interest in giving the information is greater than the harm that can be caused, still the information must be given.
I see.
So there is a heavy weightage in favor of the public, the citizen. So it really ushers in this culture of accountability and transparency and public interest. Even when you go beyond that, there are significant safeguards in terms of specific timelines. That's another salient feature. Very short turnaround times within which public officials need to respond to citizens. And there is a simple right of appeal. Fees are not charged willy-nilly. There are specific very low fee study schedules given. So all of these make sure that our Information Act is at the forefront of right to information acts across the world.
So basically, the Right to Information Act can be utilized by any citizen
Yes.
to get information which he or she requires from any public authority.
Yes.
And you mentioned that it is information that is on record with
Yes.
such a public authority.
Yes.
Let me ask you this. This act is not relevant to private institutions, right?
It can be.
It can be.
Yes. We are talking about public authorities. Let me just break it down a little more. So, it is a citizen that has the right, right? So, let us talk about who a citizen is.
Yeah.
A citizen is a citizen of Sri Lanka, and also this includes anyone under 18 years of age. You do not have to be a voting citizen. You can be a student who just wants to know about your school bus.
Even a minor.
Even a minor, right? But in addition to a natural citizen, you also have any company, whether it is incorporated or unincorporated, provided that the over 75% of their membership are Sri Lankan citizens.
I see.
So, Transparency International Sri Lanka, as a citizen, requests information. If the Maranadara Samithiya in your village wants to request information, over 75% of your membership will be Sri Lankan citizens. You can ask information in the name of the Samithiya.
Right.
Right?
Right.
So, that it is that type of citizen who can request information. The next question is, who can you request information from?
Yes.
So, the Act uses this word of a public authority, Podu Adhikarya. So, this public authority can mean many things. The Act has said that all ministries, all departments, all provincial councils, anything set up under a provincial council, all of these are public institutions, public authorities. So, educational institutions, higher educational institutions, private educational institutions.
Even private.
Even private ones.
But how is that so? Sorry for interrupting,
Yes.
but I thought it was with regards to information that is on record in a public institution. So, how would a private?
Yes. So, the definition of a public authority is actually broader than just public institutions.
I see.
So, they have brought in educational institutions that are also private, higher educational institutions including private ones. The underlying principle is that there is a level of accountability to the public. This is a public activity that they are engaging in. In addition to this, private companies or private organizations, if they have any type of contract with the state, then to the extent of that contract, you are bound to give information. So, if you are using, if you have employed people to perform a public act under a contract with the state, then in relation to that act, you can ask information from that private company, not only from the public authority related to that.
I see.
You can ask from the
Private
company that is engaging in the public activity. Then if a certain company is licensed by the state, right, for example, a telecommunications license, a banking license, any authority that is licensed by the state is a public authority under the Act. In addition to this, even non-governmental organizations to a certain extent are bound to give information. So, if you are substantially funded by the Sri Lankan state, by a foreign state or an international organization, and you conduct public activities, then in relation to those public activities, you are a public authority. So, you are bound to give information. For example, we have been asked information.
Okay.
We have responded to about 10 by now.
So, a private company or an NGO, even if it is private, is under obligation to a citizen to divulge information in terms of the Act only so far as its engagement with the state is concerned. Am I right?
Yes, to the extent of the public activity that they perform.
The public activity.
So, if they are under license, if they are under contract, whatever is covered by that contract or license, public activity will be covered.
I see. So, what are the grounds on which, even if it is straightforward public authority, like say a provincial council or a private company, what are the grounds on which such an institution can refuse information?
Right. This is an interesting question, because when the Right to Information Act was passed, there was a lot of debate around whether this act was being brought in to actually hide information.
I see.
Hide
Yeah.
information that
yes,
was that was already available. However, I must say this act has been very carefully drafted in terms of the exceptions. If you are refusing information, it's not very easy to do this, because first, that public interest override applies. What I mentioned before, even if the information can be refused because it's personal information that is not related to a public activity, if the public interest is greater, it must be disclosed. Now, the grounds on which they can be refused, information can be refused, is if you ask for personal, private information, even of a public official, that's completely unrelated to their public activity.
Right.
You want to know how your divisional secretary is, or we want to know where they live, right? Their private residential address. That doesn't necessarily account for public information. It doesn't come under the definition of public information. However, if you want to know how that person is using their official vehicle, even if they're using it for personal activities, then that would be fair game under the Right to Information Act. So, it's information that's unrelated to a public activity only that can be refused as private information. Another exception, and the much debated, discussed exception, is national security. Now, information that can be seriously prejudicial to national security, the integrity of the state, can be refused. Now, again, I use the language of serious prejudice. So, you have to show that giving the information, disclosing the information would cause not only just prejudice, but serious prejudice to the national security of the state. So, again, it's not easy to get away with refusing information. Another exception that's used quite often is third party information. You say, the public authority says that the information you have requested has been given to us by a third party, and therefore, we can't disclose it. Now, even this exception in the RTI Act has been carefully drafted. It says that if a third party has given information in secret, in confidence, and therefore, that information can be refused. And still, before you refuse it, you have to seek the consent of that third party.
I see.
And when you seek the consent, according to section 29 of this Act, you write a letter to them, there's a form. If they refuse within 7 days, then you can refuse the information. If they don't respond within 7 days, you still have to disclose the information. And if they consent, you have to give the information. So, it's heavily skewed in favor of disclosure. So, that's why this is an international principle in information disclosure, that you should base yourself on the principle of maximum disclosure. As much as possible, as much information as possible has to be made publicly available. Another exception is if the information that is being sought is protected information under the Intellectual Property Act and would harm the competitive position of a third party.
Right. So, this I assume private companies must be using that exception quite a bit.
They have been using this. So, if you can show that, you have to really justify that it can cause the competitive position of a third party, and then you can refuse the information. Information that could affect the fiduciary relationship of a person. Right. For example, if the National Child Protection Authority was asked about information about a child, then they can use this exception of a fiduciary relationship in the traditional fiduciary sense. So, there are very specific restricted exceptions which can be invoked, and they are all subject to this public interest override. Even if harm is caused, even if serious prejudice is caused to the state, for example, to state's national security, still if the information disclosure is more beneficial to the public interest, it must be disclosed.
Because of the public interest override.
Yes.
Right. Now, let's break this down, shall we, to practical aspects.
Yes.
Right. Now, let's say I want information about, say that my child was refused entry to a school.
Yes.
And it happens to be a government school.
Yes.
Right. How can do I have the right to get the information on why my child was denied entry into this school? And if I do, how do I go about it?
Yes, this is interesting on two counts. The first is that yes, you are entitled to get the information. Now, what this information is key. We can ask what were the criteria you used in admitting children to school this year.
Right.
There are circulars, etc., but you can ask that question. Then you can ask how many students applied, and you can ask for the scoring grid, right? And then you can ask for the actual scores received by everyone who interviewed.
Oh, is that so?
Yes, because all of that information will be on record with them, with the school that you've applied for your child's admission to. Now, that's one part of the law. The other part, now that's information that's on record. Now, you alluded to reasons for rejection. Now, it is unlikely that the school will have recorded why your child specifically would have been refused admission. They would have just gone with the marking criteria. However, this act has an interesting provision where they say that if any public institution, public authority rather, is making a decision in relation to a citizen, then if the citizen asks for reasons, then you are bound to give reasons in writing, even if they had not recorded it formally.
Okay.
So, on your question, so the answer is an unqualified yes. You are allowed to ask and receive information on why your child, specifically your child, was refused admission to the school.
So, even if that information is not on record in the limited sense of
Yes.
the word, because of this act, I have every right to request that information, and that the school is obliged to provide that information to me.
Yes,
along with what is on record.
Exactly. Here, this is specifically because it's the reason for a decision that is made in respect to a citizen, right? In terms of reason. So it's this, principle of natural justice, that a decision must be a recent decision, that every step has been followed.
It can't be arbitrary.
Due process has been followed. So it really crystallizes that understanding, that principle into this act. So it even goes beyond the issue of having information on record. Yeah.
So how would I go about the entire process of utilizing this act?
Yes. So under this act, I mean, sorry to be slightly technical, but under this act, there was a gazette passed, right, by the Ministry of Mass Media, which is in charge of this, and the Right to Information Commission, which specified these forms. What is the information request form? What is the acknowledgement form? What is the appeal form? So the information.
So request form.
Yes. Acknowledgements.
Acknowledgement.
Appeals.
Appeals.
All of these. How to seek third-party consent. All of these are given in terms of forms, right? This form can be found on the government website, rti.gov.lk.
rti.gov.lk.
gov.lk. rticommission.lk as well. These are both very well run websites, constantly updated. So those will have this application form. It's simple, and if you just simply Google RTI application form Sri Lanka, you'll come up with the application form. But if not, you can obtain it at the local Kutch area, the divisional secretariat. They are also bound to have forms. Now, while this form is there, all that is required is that you include the information that is requested. So it can be in the form of a letter that says, right to information request, I am a citizen of Sri Lanka, this is what I want to know. That's all that needs to be included.
I'm assuming you also have to provide such details as your NIC number.
Actually, no.
No.
Actually, no.
So how would the authority satisfy itself that I'm a citizen and I have a right to this information?
So this is interesting because, across the world, this language of citizen is not necessarily used. Any person in some countries can get information. So the idea is that, the general idea is that you don't have to be a citizen in terms across the world in getting access, There's generally no information that is, disclosable to a citizen that's not disclosable to someone else, So that's the general understanding. But the RTI Commission has very clearly said that public authorities should not ask for proof except if there is a serious suspicion that the person is not a citizen. So if they have serious reason to believe that the person is not a citizen, because otherwise what happens is that public authorities start using this as an excuse to delay the process. Just saying, as soon as you file an application form, you say, can I have an ID copy? or that's not clear, or they'll just take time. Generally, you don't have to prove your citizenship. You merely have to state that you're a citizen of Sri Lanka.
So, but what if there is a case of impersonation? What if it's not really? What if someone takes on a pseudonym and files a right to information request? How?
This is interesting because it's theoretically possible, and in fact, a lot of countries actually allow anonymous requests.
Does Sri Lanka allow?
Sri Lanka doesn't. Sri Lanka doesn't, and you have to state that you're a citizen. But the principle is that you don't have to become too obsessed really with establishing citizenship in disclosing information. Generally, if there's a serious suspicion that a person is not a citizen, you can ask for request for proof. However, if it comes up in appeal before the commission will ask for reasons as to why you suspected this. And we have a case before the commission where we've been assisting a citizen where the public authority, a state bank really, asked for proof and we provided proof on appeal. But they actually established that they suspected this.
I see.
Yeah.
So, okay, so would you be able to share with us instances where citizens have used this act and it has yielded, very good results? Can you share a few instances?
Yes, of course. So one interesting instance is in Vaunia, this village called Varikuttiur, that experienced a drought in 2017, and as a result their crops were destroyed, etc., etc. And they asked the Agrarian Services Department whether they could be given compensation for the damage that has been caused, or relief really for the damage that was caused. And they were told at that point that only people who cultivated a certain type of black gram basically would be entitled to relief, and that there was very limited funding. So upon some of us going and training them on right to information, the village got together and filed a request form asking what the criteria were in selecting beneficiaries for the drought relief, and secondly asking how much money has been allocated by the state for these drought relief purposes. And on receiving the response, they found that there was no limitation about black gram. Everyone who had suffered was entitled to relief, and that there was sufficient budget to actually give that relief, and then they received this. So this is one example.
So the farmers were able to get the relief that they
Yes,
wanted?
They got monetary relief for the damage caused by the drought. And another example, a simple example, is in Rotawala, in the Ambalanthota district. A principal had not been appointed to the local school, the Rotawala school, for a long time. And upon a training program being conducted, one citizen just simply filled in a form asking the education ministry why or what steps have been taken to instate a principal to this school. And the date that the RTI was received, an appointment was made for the school principal. So that is where they didn't receive the information really, but they received the solution that they were going after. Now, this is also an interesting distinction I want to talk about, because now that this act is working so well, and it has been working really well, people tend to think that this is the ultimate solution, that you can use RTI to get anything you want. You don't get flood relief or drought relief, you can file RTI and get your relief. That's not necessarily true. What it entitles you to is the information about it.
Right, right.
And thereafter, if the solution doesn't come, it is up to you to take it up with the Agrarian Services Department, with the state administration. Now, I can give you an example of the Vaunia General Hospital, where a citizen had been asked for a bribe to speed up a surgery for her husband. Now, she gave the bribe. However, she went and complained to the police station. Then the police ordered that an inquiry should be held. Because the inquiry was not held, this lady went and asked for the inquiry report, and it pushed for the inquiry to be held. And thereafter, once she got the information, she went and filed a complaint with the Bribery Commission. So she didn't receive her solution just then and there. She used the information to then go on to the follow-up action, holding the person accountable for the bribery and corruption that took place.
I see.
So those are just 3 examples. There are hundreds of stories of people filing the RTIs of the type you mentioned on school admissions, etc. So I would really encourage our viewers to just try it, because it really gives you a sense of empowerment that you otherwise don't have. Yeah.
Well, there you have it, ladies and gentlemen, from Ms. Sankita Gunaratna herself. Try it out. This is an act that we can all use to get what is justly due to us, and that is information from all these entities that Ms. Sankita Gunaratna was talking to us about. That brings us to the end of this week's show. Thank you so much, Sankita, for being with us this evening. I'm sure, ladies and gentlemen, that you would have thoroughly enjoyed this edition of Law and Order, because it was so informative, and I trust that now you also have been encouraged to use this act for your benefit. And that brings us to the end of another edition of Law and Order. Thank you for joining us. Good night.